the doctrine of stare decisis or judicial precedent or case law, as the case may be.
That during the class, he said that stare decisis means that to stand by what the court has decided earlier on in for past cases. So that is precedent, and you gave definition for precedent, meaning that something that has existed in the past used for subsequent cases. So I think the advantage of this precedent will be that it guides the court on the decision to make for the subsequent cases, right? That is if the facts are aligned together for these cases. And
That's
again, and whenever the court are giving a precedent, right, you also mentioned ratio decidendi, that when a court gives a judgment, there's always a reason for that. So that is one of the advantage I would like to mention.
Yeah, that's so beautiful. That's so beautiful. That's so beautiful. There's still more. There's still more. Anyone on the floor can still add to that beautiful submission. Yes, Oluwole, you want to speak? I think that's the class rep. Are you with me?
Yes, sir.
Sir.
Yes, sir.
Yeah, so who is adding to that submission just made? Yes, Adigwe.
So, so in addition to what she said, I think it can also help to ensure consistency and stability in the law. For example, you made mention of Supreme Courts, and you said their decisions are binding on all the lower courts. So it helps to ensure consistency in decision making.
Okay. You can also replace that consistency with uniformity, or you can interchange either of them. It will still go. That's also another beautiful one. Yes. Udofia, yes. Let's have you.
Good afternoon, sir.
Yeah, good afternoon.
In addition to what they've said, one of the advantages of case law is that it allows judges to interpret and apply the law in a flexible manner, taking into account the unique circumstances of each case. Thank you, sir.
Thank you. That was beautiful. Yes. Ajiboyewa. Yes.
Okay, good afternoon, sir.
Good afternoon.
For that too, we can also add that they don't it doesn't allow judges to give judgment outside the facts, which is the story being told. And we can also say they are always giving their judgment, or they give their judgment based on facts and reasons why it was given in the first place.
That's very fine. I wish you can be allowed to write your exam like a written exam, not multiple choice. I think you guys you're too loaded to be answering multiple choice questions. That's another good submission. Yes, it will have been interesting reading your mind, at least showing understanding of the topic through the answers you provide to problem questions. But it's okay. We will see that in the test. We can see that we enjoy that in the test while you face the usual style during the exam. Yes, let's have more. At least it's a form of revision to those who were not in that class. Yes, go ahead.
Good afternoon, sir.
Good afternoon.
Sir, I think efficiency, like it will be easy to give out cases. That is easy and it will not delay. Like there will not be delay in hearing cases because they just have to use the former precedent.
Okay. That's fine. That's also fine. Yes. Is that Otuororo?
Yes, sir.
All
Yes, sir.
right. Yeah, thank you. So let's have the next person before we move to the disadvantages, because whatever it is that you can say has advantages definitely will come with its own disadvantages. Yes. Who else? No one? You don't feel you are still raising your hand.
Yes, sir. I just want to add to what I said before concerning the advantages of case law.
Okay.
Okay, I just want to go to the practical aspect of this case law. Case law provides a practical illustration of how the law is applied in real life situation.
Okay. All right. That's also very good. Then let's take Victoria. Then I will say what I want to say as one of the advantages that I have discovered. And then we can move on. So let's quickly take Victoria. I think Adeola is also raising her hand. Yes.
Okay, good afternoon, sir. I'll say case law gives honor and respect judges of higher courts because whatever principle they lay down cannot be overruled by lower court.
Okay. That's also another angle to it. Yes. Adeola.
Good afternoon, sir.
Good
I think
afternoon.
one of the disadvantages is the binding authority.
One of
Like
the disadvantages.
yes, disadvantages is
Okay,
the
you're already
binding.
talking about the disadvantages.
Yes, sir. Is the
Okay.
binding.
Yes, if you say binding, I do not.
Binding authority. Let me
Can you
explain, sir.
clarify more?
The judges are also human. Sometimes they made a mistake, but due to the binding authority, it is very hard to make a changes in the law made by the judge. So that makes the case ruled by injustice.
Okay, so what you are trying to say in essence, which I think I understand, is that it can aid perpetuating mistakes or
Yes, sir.
errors that may have
Yes.
been committed. Okay, so before we delve fully into the disadvantages, I said I was going to say something about the advantages. Now, one thing we have established in the course of this class is that the judiciary does not really have the function to make law. But in a way, the judiciary can also make law for the well-being of the community by the function of interpreting the law. That's why when somebody said that it helps the interpretation of the law in accordance with facts, and that sometimes the interpretation indeed brings light into the intention of the lawmakers, that is the drafters. Okay, so that's good. Then let's look at the disadvantages. Someone has already given us the fact that it can propagate errors, and of course, which consequently may lead to injustice. Yes, Stephanie.
Okay, so for the disadvantage, you gave one of the disadvantages that say that it may lead to case being premature, right? Like premature ruling. And what I understand by that is sometimes this judicial precedent this case law, right, of judicial precedent can be so rigid that sometimes they may be bad decisions made in the past might apply or might be binding to the lower court. And sometimes the courts might not even have so much time to look into these cases to give their own discretion of it. They just have to apply the precedent that was applied in the past to the subsequent cases.
Okay, let me enrich your knowledge more about what I said on that point, that it may help to propagate rules that are at their infancy stage. Now, irrespective of the knowledge that the justices of the Supreme Court or the higher court might have, human beings are not perfect. Even the wisest man can make mistake. The wisest man can do something that, if tested properly, will discover that it's not really the best option that is available. So sometimes when judges give interpretation to laws, and it's not in their perfect state, and then you now apply it, it's like giving what is not fully right to the society. But let's say if the rule that was developed by the judge in the course of interpreting the law goes through some stages of refining, maybe another judge of the higher court will look at it and said, based on this rule, and develop on that rule to make it, look more robust. Then with time, one will now be able to come up with a kind of rule that may not have any blemish. For example, I talked to you about the case of a duty of care, where we talked about, I can't remember the case particularly now, where it's Donoghue versus Stevenson, that whether a manufacturer of a consumer goods holds a duty of care, and that a principle of neighborhood was developed in that case. And the rule was that who is your neighbor in law? Your neighbor is not the one that is living next to your apartment. But basically, that is the interpretation we give to neighborliness. Who is your neighbor? Your neighbor is not the man living in the next house. Your neighbor in law, based on that rule, is that anybody who will be affected by what you do is your neighbor. Meaning that if you suddenly wake up one day and you say, this road that is in front of my house, you just take an excavator, then you destroy the road. Please, can you give me just a second, please? I'll be back shortly. Hello, class. Sorry for the break. So, I was explaining that if you suddenly wake up and you say, this road that is in front of my house, you carry your tractor and start clearing, destroying the road. Now, that road is for the public. Someone can be coming from Kogi State, and that is the only route that he has to take to his destination. If by the time the neighbor, that human being, got to that spot and is unable to use the road, that man, even though his place of residence is in Kogi State, becomes your neighbor. So that's a principle. And so far, there has been nothing to water down that rule, that who becomes your neighbor. And the law says that anybody who will be affected by your act is your neighbor in law. So that principle developed and is standing. But it may not be like that when it was developed. So many things may have happen to it to become as beautiful as it is now. So that's the doctrine of judicial precedent can help to perpetuate maybe a rule that is supposed to be that is the infancy stage becomes something that is now being applied as a fine-tuned or perfect rule. Okay, I think I've been able to add to your knowledge over there. Yes, so let's look at other disadvantages.
Okay, sir. Good afternoon, sir. I think it's too the complexity and volume, because it will not be easy for the judges and lawyers to like know all the cases, all the past precedents that will be needed for them in a particular case or cases to come. Sir, do you get me?
Yes, I do. Where the angle you are looking at it is also okay, but the lawyers are required also to do their findings. I agree that that's even why Lord Denny said, God forbid that a lawyer knows all the laws, but that he must know where to find the law. Yes, it may be voluminous, yes, but at the same time, the lawyer also has a duty to do the finding. That's why he receives payment for his services, just so to speak. Yes.
Good afternoon, sir.
Good afternoon.
Yes, I think one of the disadvantages is rigidity can influence injustice. Like the case of that man that you said was in prison when he was given a notice to vacate his house, is that the judge had not used golden rule of interpretation to judge that case. If he had used like judicial precedents, the man would not have been.
If he had used literal rule of interpretation.
Yes, for the case, the man would not have gotten justice.
Yes. That's beautiful. Yes. Who else?
Good afternoon, sir.
Good afternoon.
So I think one of the disadvantages is limited coverage. Case law may not cover all areas of law, leaving gaps and uncertainties in the legal system.
Can you explain that a little? Can you try and explain that a little? No. Okay. Yeah, next person. Next person. Who else?
So you said that it has the effect of limiting judicial discretion. So like some judges, they might not like go deep into the facts given to them. Once they see that it's similar in a way to the previous case, they'll just apply the verdict given in the higher courts without like checking it very well to see if it's really similar or not. And it can bring about injustice as well.
Okay, that can be easily classified under the fact that it can bring about judicial laziness, if there's anything like that. It can bring some form of laxity on behalf of the judges. But the other thing I saw from what you said is that, which I need to explain to you when talking about the fact that it limits judicial discretion. Now, how many of us are, okay, don't let me even go to the case of Rivers State. What is happening in Rivers State? Or let's take that as an example. Do you know that every one of us have different views of what happened in Rivers State? I'm talking about those who are aware of what happened, though, because there are people in this class who may not be aware of what is happening in Rivers State. But we all have different perspectives to issues, and we all have different ways of addressing issues. So when we're talking about discretion, is that when a case is presented to you, the way you will address it may be different from the way another person will address it. If, for example, somebody paid Mr. B paid Mr. A the sum of 20 million naira to supply cartons of milk. And upon receiving the money, the man fell ill. And on his sick bed, he remembered that I have collected 20 million naira from Mr. A. He now called on his first son and said, please go to Onitsha. Go to our truck park, pick 5 trucks, go to so and so place and load cartons, so number of cartons of milk and deliver to an individual. And while they were on their journey, they were ambushed by robbers and they hijacked all the products. In contrast, Mr. A is still duty bound to supply what he has been paid for. But he had the intention to do that, but that intention was frustrated by unforeseen circumstances. So let's say that the higher court has ruled in that case before and said, irrespective of whatever happens to you, once you have collected money, you are duty bound to supply. And then there's a similar case that has come before a judge. The judge may want to apply it stricto sensu like that. But there is a place for discretion. That place may be that, oh, this man indeed had the intention to supply this product, but some unforeseen circumstances prevented him from doing so. But because of a judgment that has been handed down on this similar matter, that judge may not be able to apply his discretion to say, okay, give him some time to get well, because I've seen from the fact that he has a good intention to deliver the product, that let him give him another chance. But judicial precedent or case law may not give room for that, because the law must be applied as it is based on the judgment that has been delivered. Okay, so that is one way that I can explain that issue of judicial discretion. Yes, Udofia, you have something to say?
Yes, sir.
Okay, go ahead.
So yeah, sir, it's more like me saying one of the disadvantages of the case law, and also want to ask a question. There's a question
Okay, go ahead.
as well. So I would say one of the disadvantages of case law is inconsistency. For instance, now we know that case law is a law that originates from previous cases, and it is also known as judicial precedent, and precedent can be defined as previous judgment. So concerning this case law now, is it compulsory for judges to judge a particular case from previous occurrence? Or because I believe that judges have different opinions in terms of cases. So is it mandatory that they, you understand, is it mandatory that they judge a particular case from previous occurrences, or just state their opinion about a particular case?
Well, it is a rule that must be followed. But if you were in our last class, we did say that there are times where a judge may not follow strictly what was contained in the previous judgments. And we gave our reasons, which I'm still going to repeat for the purpose of this class. Okay? Now, a judge can also express his opinion, because I'm glad when you said that judges also have their opinions. Yes, just like human beings, they are also human beings. They have their own opinion. But while applying judicial precedent, they have a duty to apply that law that has been developed by the higher courts and give their opinion by the wayside. But while their opinion does not form judgment, the judgment that was applicable in the previous case may hold sway in this present case. That is, the court may apply it, despite the fact that he has a different opinion. But he may express his opinion. And that opinion is what we have defined or we have talked about to mean obiter dictum. But again, I said that there are situations where a judge may not apply that law in his present case. And what are these exceptions? Number one, exception is that if the reason given for that decision was considered to be obscure, strange, that does not follow logic, or that does not follow normal reasoning, or a kind of judgment that was obtained by fraud, as good as we will say that our judges are, in every 12 there is a Judas. So someone sometimes may have collected bribe and then will give a judgment based on what he feels. If that judgment is proven to have been obtained by fraud, you may not need to compulsorily reaffirm it in a subsequent case. Or maybe the court arrive at the judgment in ignorance. Maybe there was a law that used to be in existence and that law has been changed, and the court applied that law on the case. That judge has ruled based on ignorance. The lower court can choose to say no, as at the time this higher court decided on this case, the law which formed the ratio decidendi was no longer in existence. Therefore, the court will not be bound to follow it. And then another reason is where the judgment was reached per incuriam, what we call per incuriam. Per incuria is a Latin maxim, P-E-R-I-N-C-U-R-I-A-M, meaning that it was reached through lack of care. That is, there was no proper consideration in arriving at the judgment. Is another ground where a lower court may choose not to follow that rule. But it is not something that is easy for a lower court to do, because if you fail to follow the law as enacted or as arrived at by the lower court, upper courts, if that judgment is appealed against, the higher court may still strike it down and say, since there is a judicial precedent on this, it must be applied. Okay, so those are the various exceptions where the lower court may choose not to follow the decision of a higher court in a particular matter. Okay, all right, so I think we can stop with that revision based on the last topic, so that we can make progress on this particular topic. I'm sure one way or the other, my colleague will take over from me, maybe as from maybe in our next class or thereabout. But let us take on customary law as a source of Nigerian law. Okay, what is customary law, class? What is customary law? Yes, please go ahead.
Customary laws are laws of various indigenous people, like customs accepted by the members of the community as binding among them.
Right? Beautiful. Yes. Yes, Udofia.
Good afternoon, sir.
Yeah.
Customary laws are laws that are made based on the customs and norms of people in a society that they have accepted as binding on themselves.
Okay. Yes, who else?
So customary law can be seen as the traditional norms of the indigenous people of a state.
All right. So now let me ask the class. Why should we classify customary law as one of the sources of Nigerian law? Why?
So I would like to say that since customary law is from the traditions of the people, and the people are those who are supposed to obey this law that are being made, I think that the law or the sources of law should be based on how the people act or what the people do or the morals of the people in the society, so that it will be easy for them to actually obey the law. And it seems that customary law being the source of law is for the lawmakers being considerate of the fact that the people are the reason why they are making this law.
Yes, my question is, we are looking at sources of Nigerian law. I have just asked, why should we classify customary law as one of the sources of Nigerian law? Why should we take it as one of our sources? Yes.
Sir, I have an answer.
Okay, go
Sir,
ahead.
in the definition of, I have a personal description of law, and that is rules and regulations that are binding on a certain set of people, that are binding on the people and are enforceable by the state. That's just paraphrasing. And you can tell in that definition that it's binding on the people, which means the people have accepted it as binding, which means they have agreed that, oh, if you don't adhere to this, then you will be punished for it. And for the people that agree to that, it has to be something they are familiar with, which is why some of the customary laws that we had before the legislative system in Nigeria was established, some of them are still like applicable today. And also in the features of law is normative, which means it's also according to the norms and the customs of the people. They won't just bring like a law. For example, if they brought a foreign law that doesn't apply to any Nigerians and then they impose it on us, obviously there will be backlash. People will protest against it. So it has to be something that the people can relate with.
Yes, I agree with that submission, but my question is still hanging. Why should we classify customary law as one of the sources of our law? Yes,
Sir.
Esther. Yes, go ahead.
So it ensures that indigenous legal system remains prevalent. Like it helps to protect and strengthen our cultural traditions, so we don't get lost in modernization.
Okay, so that's your reasoning. All right. Yes.
Yes, sir. I believe it is our history, because even before the English law or the creation of Nigerian legislation, customary law has been in practice in the different traditional establishments, like the Yoruba custom had their law and their enforcement of the land, people that enforce it and things like that. So if you remove it from one of the sources of Nigerian laws, it's like you're removing our history and tradition, our foundation as a country in general.
Okay, I think I get your argument. Yes, next.
Good afternoon.
Yeah, good afternoon.
To what Annabelle and I think Rosemary said, according to what they said too, in Nigeria we have different traditions, different customs. So the reason why it's part of the sources of Nigerian law is because there are different customs that have different practices. They have different rules and regulations so they have to like go with the order and go with the flow with it to add up to the laws to be able to govern the people.
Okay. All right. Thank you. Yes.
Okay. Good afternoon, sir.
Good afternoon.
Yeah, it's Udofia. Sir, I would say one of the key reason why it should be classified as one of the sources of Nigerian law is because of its cultural insignificance. Because we know quite all right that Nigeria is a cultural diverse country. So recognizing this customer law as a source of law promotes and celebrates this diversity. So I think the key reason is its cultural significance. Cultural significance.
It's not insignificant. If you use the word insignificant, then you'll have turned it upside down.
No, I said cultural significance, sir.
And you were using insignificant. That's why I wanted to correct you. Yeah, thank you very much. Joel.
Yeah. Good afternoon, sir.
Good afternoon.
So, based on the definition of customary law, we say that because it is something that the community have accepted to be binding among them. So, before the English law were being accepted into the country, we're already operating with our own rules, which make it something that we've already get used to it. So we'll say that it is part of the Nigerian source of law, which we have already been used to the system. That's my opinion.
All right, that's beautiful. Yes. Let me take as many hands even though I have about 17 hands up. Yes.
Good afternoon,
Good afternoon, sir.
Yeah, good afternoon.
Okay.
Customary law is a source of law because it has been put into the laws we have today. Like some of the customary laws have been put into the Constitution, I think.
Good afternoon, sir.
Good afternoon, sir.
Yeah, you conclude your thought.
Good afternoon, sir.
Yeah, good afternoon.
Sir, I would say customary law is taken as a source of law in Nigeria because from the very beginning, Nigeria have set their own law even before
Sorry,
the
Adedoyin, please can you hold on? Somebody else is talking to somebody else.
Right.
Yes, go ahead. I'll remove the fellow. Yes, go ahead.
All right, so as I said from the very beginning, Nigeria have set their law. They had their own law before the introduction of the English law. And Nigeria is known as a country that follows culture and tradition. So there's no way that they will kill that tradition, never. Because even in some parts of Nigeria, yes, we know that the English law have taken all of their heart. But in some very typical place, we know that yes, the customary law is still available. So there's no how Nigeria won't follow their customary law, sir.
Okay, I'm sure if anybody should give you gun now to kill anybody that wants to remove customary law as a source of Nigerian law, you will kill the person.
Yes, sir.
All right. I saw that from your submission, and honestly speaking, that is the place we are supposed to take it from, because that system of law has been what was guiding our affairs before the evolution of the English system that later dominated our system. Okay? So, therefore, it's going to remain one of the most important aspects or sources of our laws, just the way somebody wrote in the question and the answer section. Okay, so let's move on that source of law, which is customary law. And in my previous classes, we have defined customary law through cases. And then we talked about the fact that customary law is the organic or living law of the indigenous people of Nigeria. And as a matter of fact, many of you have alluded to that fact when you gave the definition of customary law. And then what then we will now look at is that when you look at this definition that we have talked about relating to customary law, we can itemize the basic characteristics of customary law. Okay? Basic characteristics of customary law, which includes, we can have up to about 10 of them. Do we have people in the class who can mention at least one characteristics of customary law based on the definition that we have advanced in this class? At least to show your understanding of what we are talking about. Yes, please. Go ahead.
Good afternoon, sir.
Good afternoon.
I think it's binding and accepted by the people.
Correct? Yes.
Good afternoon, sir.
Yes, good afternoon.
The way and the manner and the history of the people.
Okay, yes, that's correct also.
Good afternoon, sir. Good afternoon, sir.
Yeah, afternoon.
Yes, sir. It is based on the tradition and custom of the people.
Okay. Yes.
Good afternoon, sir.
Good afternoon, sir.
It is flexible and dynamic.
It is flexible and dynamic, that's correct.
Good afternoon, sir.
It is
Yeah,
unwritten.
afternoon.
It is unwritten, sir.
It is unwritten. That's another very valid point. Yes.
It varies according to your region.
Varies according to geographical location and region. Yes.
Good afternoon, sir.
And
Yeah, good afternoon.
there's no sovereign, like there's no, it's not enacted by a sovereign.
Okay, yes, that's another, key important characteristics. Yes.
Community based.
It is
Flexible and dynamic. It is community based.
Is
It
what?
is based on usage and custom.
Okay.
Based on-
All right. That's okay. That's a very correct point that you have mentioned. So, in summary, the characteristics of customary law include the fact that it must be in existence at the material time, and then that it must enjoy general application among the people. That's why someone said that it must have that bindedness within the people that has recognized that particular rule of law as a customary law. Then it is largely unwritten, as rightly said by members of this class. Then also it differs from tribe to tribe, from region to region, and then it is not a frozen or rigid system, meaning that it is a flexible system of law that accommodates various situations as the case may require. And also, one of the major characteristics is that customary law is based on the custom and usages of a particular people. Okay?
Because those people do not have good notion.
Yes, sir.
All right. So that's okay. Yeah, so with that, let's move to the validity test that no Uforiji, you have a question?
So I have a question.
Okay, go ahead.
The customary law. I want you to please clarify for me. The Sharia law.
I think we cannot hear you clearly.
She asked if the Sharia law is a customary law.
No, Sharia law is not, later on we will discuss that, but Sharia law is not customary law. And when we start discussing Islamic law, that's one of the major things we are going to say. And that the reason why it was referred to as customary law was because of the fact that our colonial master taught it that wise, that customary law and Islamic law should be made as one. But in the real sense of it, Islamic law is not a customary law. As a matter of fact, when we are discussing that, we may have cause to say that customary law, why customary law is based on tradition, Islamic law is based on religion. So we'll come to that later on. So now the next stage we have to take this discussion to is that, sorry, confirm to me, Oluwole, do you have a class by 2 o'clock? I'm not sure it's there. Okay, let's continue. You can send me a message when you are back on. Hello, class, can you hear me?
Yes, sir.
Yes, sir.
All right, that's okay. So let's move on. Now, we need to establish that it is not every custom of a particular ethnic group in Nigeria that is regarded as customary law. The reasons are obvious, and we are going to look at those reasons also in the course of this class. For any rule of custom to be recognized as a customary law of the people, it must pass through what we call validity test, okay, before it can be judicially noticed or recognized as a customary law. And this validity test basically is divided into 3, okay? And anybody who has attended our previous classes tell us these 3 tests that a custom must go through before it can be accepted in our law as a customary law. Yes.
Sir, good afternoon, sir.
Good afternoon.
The repugnancy test, the comparability test, and the public policy, sir.
Public policy test. Okay. Yes, who else?
The validity test, compatibility test,
Compatibility test.
repugnancy test, public policy test.
Okay. Now, why do we have to apply these tests?
Probably for the proof of.
I believe I've taught this class, this topic through other lecture time. So let's do this interactive session to refresh your memory and so that you can also grab it more. Yes. Are you there?
Good afternoon, sir.
Yeah, good afternoon.
Yeah, so I believe the validity test is the informative machinery of customary law.
Sorry, your network is breaking.
Can you hear me, sir?
Yes, I can now.
I said I believe the validity test is the informative machinery.
No, I cannot hear you. Sorry, the network is not okay. Okay. Yes. Maybe you can send us a message.
Sir, your question was why do we have to do this validity test, right?
Yes. Yes.
Okay. So we have to use them because not every custom of a particular ethnic group can be regarded as customary, because some are repugnant, some are archaic, and some just don't apply to like how things are in current day society. So we have to go through all these steps to make sure they adhere to certain principles before they can be regarded as law.
Okay. So what we are saying in essence is that there are customs that are not fit for application as customary law for obvious reasons. Some of them because they do not accord to present day reality. Some of them because they offend instant rules, or because they do not accord with reason. Okay? Yes, Oni. Oparaji. Yes, who else? Samuel, Stephanie.
Okay, so I think I can remember where you said that this validity test is in place because of the good conscience and equity, and to avoid these laws from being barbaric. So they have to go through this validity test. And the day we were teaching about this validity test, we mentioned some laws that does not make sense, right? So some people mentioned about the Igbo culture and tradition, the Yoruba culture and tradition. I think a person mentioned where a widow has to stay indoor and mourn her husband's death, while whenever the husband loses his wife, he has to go out and enjoy himself. And we said that was barbaric and that is unfair to the women and culture. So yes.
Yeah, that you were in that class. That's beautiful. Yes. Let's take Giwa.
Sir, it prevents misleading conclusion.
What?
It prevents misleading conclusions.
Okay, so if the tests are applied, then it can, give good conclusion or a good and better.
Yes,
it's
sir.
Okay. So what we'll do is that we are going to stop here for today. I think I remember usually, whether a part of you or so, usually have a class by 2 so that I don't eat into that class. So by the time we reconvene, we will start with the 3 tests that we are going to look at under this topic, which are the repugnancy test, the compatibility test, and the public policy test. So see you some other time. Let's stop here for today so that we can give room to others who will need to also attend other lectures. All right, I thank you for participating in today's class. Do enjoy the rest of your day.
Thank you so much, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Bye-bye,
Thank
sir.
you, sir.
Bye bye, sir. Enjoy your day, sir.
Have a nice day, sir.